I love hearing all your stories. Before I get started, one thing that I think that I have to say is that these are my views. These are not necessarily the views of the judiciary, of anybody else in the judiciary, but me. It is not a view of the folks who I sit with necessarily. I can only speak for myself in my experience. I'm so very thankful to you guys. I'll tell you a little bit about my story first, and then I'll go right into it. I won't take long. I'm a Maryland boy, Southern Maryland guy, grew up. Charles County is called Chuck. We used to call ourselves Don't Give a Chuck County. That's how we referred to ourselves back in the day. We were young and hot-headed. I went to school at Texas Christian University. I actually had left, home and tried to go as far away as I could. Saw a little school, had a mascot of a horned frog. Did not know what a horned frog was. Thought it'd be a great goof to put on my parents because they were pushing me to apply. I applied, I went, and I loved it. Absolutely leap of faith. Loved it. Met so many different types of folks. And it became very clear to me that for a lot of them, I was the East Coast progressive guy. If they ever wanted a viewpoint that they thought was going to be East Coast and or liberal and or progressive, they'd be like, hey, where's Zoo? Zoo, come here. What's your view about X, Y, and Z? And I'd be like, well, this is kind of what I think. These are my views. And they'd be like, yeah, East Coast, right there. After I graduated from TCU, I came and went to law school at American University, right here in Washington, D.C. I quickly learned that they saw me as the conservative Texan. And they would say, oh, we need a different viewpoint. We need a conservative. Zoo, come over here. Tell us the conservative viewpoint. And I'd come in and be like, I'm the same person that I was 2 years ago that I am today. And they'd be like, oh, just give us your view. And I would tell them my view. And they're like, oh, see, Texas. I learned from those experiences that individuals matter. Stories matter and who you are matters. And not just where you necessarily come from or people perceive you to be. And that's been part of my journey in coming to the bench. I know this to be true, that I'm kind of different than most judges, and I get that, right? Folks who Google me know I was one of the youngest judges appointed, got appointed at 35, got on at 36. Somehow I end up now being one of the more senior judges in Montgomery County because other folks retired. But always through that, I always remember that story about where I went to undergrad and then where I went to law school. My mother's from South America. My dad's from the inner city of Chicago. My mother saw education as a way to leave Guyana, South America. And my dad found a way that education was his way to leave the South Side of Chicago during its most turbulent times, the 50s and 60s. I was born in DC, but lived in the Maryland suburbs. And everything that I do reminds me of what my parents went through, what I've gone through, and why I'm here. Because I'm one of the younger judges, when I tried my cases, it was in DC. Not homegrown like a lot of the folks in Montgomery County. There's nothing wrong with that. It's just not me. My practice was in DC with a multi-door mediation format. Now, after law school, I clerked for Chief Judge Bell. I went to Venable, then went and did a federal clerkship in the Eastern District of Virginia for Judge Gerald Bruce Lee, but landed at the Office of the Attorney General in DC. Multi-door, as you guys know, is part of the process. So that's the way that I learned. Wasn't a hurdle, right, to get over. Oh, I gotta check off mediation. I gotta check off settlement conference. Oh, what track were we on? Check it off. It wasn't that. It was something different. Maybe it was more like the federal model where you have to go in, you sit with the magistrate, and they go back and forth, and it has to be a genuine conversation, and you got to bring some money or bring something to the table at the time. But it was my understanding of how things work. Not that ADR and mediation were some newfangled thing that folks were doing, but it was part of the system. If you think you want to file a lawsuit, know that mediation or ADR is part of it. And I've tried to bring that here on the bench. I wish I could tell you a story about how easy it's been. I wish I could tell you the story that when I got on, everybody said, "Oh, that's a good idea. Let's do it." But you know that that's not the story at all. The story is winning and trying to persuade colleagues of mine that even though you could get through your docket faster by not waiting for the mediators to get through their opening remarks in a side room, that may not be what's important for justice. That may not be what's important for folks to actually be heard. To feel like they're part of the solution. I go fast. People know that when they're in my courtroom. But mediation and ADR is part of the process because I don't know everything. And going to trial isn't necessarily the best thing for a lot of folks. I understand that if you're at loggerheads and you can't move forward, that you may need a judge to intercede, but sometimes people need just a little guidance to look at things a little different, to have somebody reflect back to them the things they're saying, maybe find a truth that's going to be missed in the evidentiary process or the civil procedure process, or in sometimes community, so the criminal context for some criminal cases. And you do a really good service in doing that. I like how a lot of you talked about some of the judges that came before me. And I've been very lucky to have two really good administrative judges who were on when I got on the bench. I'm on the bench 8 years now. I'm on my third administrative judge, Judge Wolf. Making sure that when I came in, and we used to have lunch over at, I think, Apollo, right there in Rockville with the mediators. I mean, Judge, why am I going to lunch? This is my lunch. I can do other stuff. He says, there's so much wisdom and thoughtfulness, and they do such a good job that you'd be a fool to leave it on the table. You don't know everything, and they may not know everything, but they're going to have points of view that you may be considered and may have you be more thoughtful about how you do your job, how you can empower mediation to do their job better. Not because we're trying to be elitists, because at the end of the day, it's about service. And Judge Wolf, I will always be thankful for him pulling me aside and making sure I went to those lunches and engaged folks and listened. The next administrative judge that we had was Patty Mitchell, the daughter, not the father for you Montgomery County folks. And I've spent most of my time with Patty. She stays being my mentor today. I talk to her today. I talk to her all the time about it. And her view about mediation was exactly my view. You got to give folks the opportunity to do it. It's part of the process. Sometimes we can't fix everything. And just because we rule does not mean that we are right. Those two administrative judges pushed me to be the chair of the subcommittee. So on the ADR larger committee, but then the district court subcommittee, I was the chair for a little longer than I thought I should be, but for about 5 years on it. I had to go to another term because they needed somebody else doing it. But now we have other folks who are doing it, which is great. And that's when I really experienced a lot of you folks, a lot of what's going on all over the entire state. Back when I was an ALJ for the state, we also did training and mediation. And when the foreclosure mediations came in, that's where we're doing the most. We did it mostly in Prince George's County. There were a lot of foreclosure mediations in Prince George's County at the time. But why am I here talking to you guys? Is it to tout out all the stuff that I did and how I believe in you and the process? No, not at all. I'm an old head. Folks know that. I love pop culture. And as I was getting off the bench today to go pick up my kids, I got that same text that y'all got in your WhatsApp groups, your iMessage groups, and all that other stuff. Tina Turner passing away. She is an icon. Was an icon, is an icon. One of my favorite singers of all time. Was one of those singers that you could actually listen to with your parents in the car. That you knew the lyrics, that it was very pop culture-y, and that I even listen to my 3 kids now. I used to teach a class of domestic violence and What's Love Got to Do with It, the movie, which should have won an Oscar, but we'll let it go. The movie, we talk about all those things and how her story of her faith, her love of her children, the love of music, and how you can come out of something so difficult and move forward. So I did what all folks of my age do. I got sentimental. And I started blasting Tina Turner songs, picking up my kids, having my kids listen to it, dropping my kids off, making them dinner, the whole thing before I got here today. And one of the lyrics from the song, the best, or people call it simply the best, but it's the best, goes like this. I'm stuck on your heart, and I hang on every word you say. Mediation is the heart of what we do. We are stuck there because we have to listen and hang on the word to what everybody said. The rules of evidence don't get in the way. The social dynamics of rich and poor don't let you listen any less. When people think that the fix is in with the judiciary because of who they are, what they look like, and how they choose to love, mediation is always there to hang on every word they say and try to find a path forward. I am jealous of you because I don't get to do that. There are rules, and especially in large claims, that actually prevent all that from coming. But when you sit in that room for folks, you matter in a way that I can never matter. That Judge Fader, the Chief Judge of the Supreme Court, we renamed it, the Supreme Court of Maryland, can never reach anybody. Or our new admin. Or any other judge that thinks that they're hot stuff on the bench. Why does that matter more than ever? Because we are at loggerheads with each other. No matter how much history has taught us about how to try to move together and talk to each other, we end up at a point in 2023 where the cases are stickier, people have put their heels in the sand more, And sometimes it feels like we're spinning out of control. And I know you feel it too. This is not something I made up. Is it worse than it has been in the past, or is it going to be worse in the future? I don't know. But what I do know, that in this moment, we are in the age of anxiety. I see it on the faces of the lawyers, but more importantly, I see it on the faces of their clients. The time that you spend in there, having one side tell their side and have another side tell their side, and then shuffling back and forth and caucusing. Listening to and reflecting back to somebody the essence of what you think they said to them. Not cutting them off when there's something that they're trying to get across, or that they're inarticulate in a way that maybe the other side is just not hearing what their true concerns are. That is a human aspect that you're able to do and reach folks, and that I'm not able to do that. And again, I'm jealous. Don't give up the hope when judges don't send folks to you. Come to me. I'll try to do it. I'll sing your praises. Because at the end of the day, it's not about us. It's about the clients, the people. We are a service industry, period. I know sometimes it feels like you go home and watch TV, or somehow you come back and say, Judge, they didn't settle. I tried my best. You think that that doesn't matter either. You will be surprised a lot of times that you get them to narrow the issues, come before me, and they get a taste of, whatever it is that the judge is presenting, and they change their minds, even after you've left. That matters to what's going on here. I wish there was a magic potion that said, hey, this is always going to be true, no matter how sticky and polarized we have gotten as a society, that you're going to be able to win the day all the time. You're not going to. That's not true. But what you can do is move the needle slightly. And from the experiences that I heard from folks, and what they did before, whether it's NIH or being a federal ALJ, or being a part of a unit that is pushing human rights, ADR in DC, and doing all these things. These are things that we need to do to move us closer together. The cure, the remedy of where we are today is not talking less. It's doing more mediation type things. Being trained by Tim, as everybody has, seems like. Those things matter. Do you mind if I share with you something that judges don't do very well? And I'm constantly reminded by my wife, my kids, and my family. Judges always think, not all judges, but a lot of judges think that they are magical. And when we get to the end, or a case settles, or just whatever, it's because that we have done some mastery of whatever occurred. And forget about all the people who are a part of that process. And I've seen some of you be a part of the process. But the one thing that I've lost all manners about, and I have to chide myself and be chided by the people I love, is to say this. Thank you. It's simple. I'm able to do my job better because you exist and you hang in there. I'm able to do my job better for the people of my county and the people for the state because you spend the time trying to disarm folks and try to have conversations with them beyond it. My job is made easier by each one of you and your wisdom and all the stuff that you bring. Oh, I'm retired. You're not retired. You never retire from public service. Y'all know that. You are always helping and doing that. And to the extent that I have forgotten to say, thank you very much, or give praise in every part as I sign off on an opinion or or a decision, knowing that somebody has been there before me. I apologize for that, and I'm very, very thankful. And this is where I will speak on behalf of the judiciary. Thank you. We got a long road ahead. And you can tell by the bags under my eyes that I'm tired. Other judges, we talk about it at lunch now. The moment we are right now is so sticky, it's difficult. Every case is a challenge because everybody thinks somebody's either out to get them, the judiciary is rigged because they see what is happening or perceive what is happening in the greater nation. And I'm exhausted. But you know what fills up my tank? Hearing stories from folks like you. Knowing not to give up and to move forward, not because somehow at the end of the day, we're doing more good than not. But the essence of being focused on the heart of individuals, being stuck there as the heart of judiciary and hanging on the words of everybody is difficult. And it has to be done by somebody. If not you, who? If not now, when are we waiting for? The best way to unstick sticky situations is have people talk, and that's what you do. So let me end this by saying a couple things. Keep creating ways forward. If they're novel things, don't just say we can't do it. Maybe you try to do novel things in the world of ADR. Push the limits. We know from, or I know from being the district court chair or the subcommittee chair, that other states are envious of what you're doing. They come and watch you. They watch us. They do it with the ADR mediation for the state, but also folks that we send and say, folks do good jobs, especially here in Montgomery County, but all over the state. Keep being creative. Do not be afraid to ask the judge for more time so that you can be creative. Do not be afraid to ask for a postponement and to come back or do something later because you're running out of time, because you guys are the ones with the wisdom. So long as it's a voluntary process and the parties want to go forward in that process, judges should be thoughtful about that. Number two, sometimes you got to refill your own tanks. And you do it collectively with these types of meetings, the in-service, pushing other people to do the 40-hour mediation over at Montgomery College, talking about your experience and how you were helpful to folks in a day. That helps refill yourself. And number three, never be afraid to speak truth to power. If you're in that courtroom and you think the judge is pulling folks out and frustrating the process, I know that you feel like you're just an appendage and you can do it, but it's okay to say, Judge, I think that this is beneficial. I think that I can get there. Give me a chance. The worst thing the judge can say is no. But being brave in those moments matter and matter to folks. You are the best. It's not me. I can take a lot of credit, but it's not me, it's you guys. I'm stuck on your heart, and I hang on every word you say. Y'all are simply the best. I am completely open to any questions you may have. Anything about my background, what happens, if there's specific issues, if there's a more broader thought process that you want me to talk about, or they're just concerns, or you just want to be able to let me in this moment fill up your tank. I'm completely open to it. Does anybody have any questions for me or anything regarding any of the comments I said or anything you just thought of? Tim.
Thank you, Judge Williams. I mean, your speech brought me to tears. But you mentioned something that I was curious as to how we as mediators would go about doing it. And so, sometimes we would do, like, say, a pretrial mediation, and we know that the parties have a trial date. But after 2 hours of mediating, they have made progress, but they haven't been able to resolve their dispute. And the trial date is really close. So how will we go about, or how will we suggest to them to go about postponing the trial date?
Yeah, it's a good question because there are a couple of forces that I think are going against each other. And again, now I'm going back into my personal, not the judiciary.
Hmm.
You know, a lot of admins are trying to clear the dockets, right? They're not trying to have stuff on from 2020, 2021. But there is some value in that particular case that you think, if they're not going to ultimately resolve it, that they're going to really narrow the issues, right? To something that is, if it's A, then it's, go this way. If it's B, it's going to go that way. We talked about this in the subcommittee a little bit. I wanted to have something a little bit broader for each district court and then for circuit court as well, where mediators can send a letter to the judge, because you really can't say, the confidentiality of what's happening, but that judges would trust the mediator when they come in and say, Judge, I think there's beneficial, right, for there to be another session of mediation. In same day, the quicker you can get that information to the judge, the better, especially around lunchtime and especially around 4:30, right? That's when the judge is, what's going on, right? If you can get it to a judge earlier, most judges that I know are open to it, saying, hey.
I think what he's saying, Judge Williams,
Yeah,
he's doing it from we have a special program. We're one of the ones who started it for the state, which is the pre-trial.
yes, I'm going to talk about
okay,
and then I'm going to back up to what it looks like for pretrial, because we discussed that in the committee, right?
Okay.
Yeah, and so let me just skip the pretrial, so we'll just get there, right? So for pretrial, what I would suggest is that there be a conversation with each administrative judge, right? And it has to come from, when we talked about it in the mediation committee, was how to tell the judges ahead of time and push it and get it pushed back. And what we've talked about, and what I think is a good solution, is if there's a notice that comes out of the mediation saying there should be additional time for it, that somehow the judges have to trust the process, even if they're trying to clear the dockets, even if they're trying to figure out what's going on, because it may clear the docket in that respect. And so for the pre-trial, if you think there needs to be another session, another 2-hour session or whatever, I think that you reach out right away. The way we had thought about it was, who does it go to? Does it go to an administrative JA? Does it go to the administrative judge? How does that happen when it comes out of the pre-trial mediation process? I think so long as it's sent. And I'll tell you why I think it's okay. Because in other cases, we get agencies and other folks sending us letters all the time. If safe passage, for instance, isn't working out in a criminal context, for violation of probation for stages, they send us a letter. Judges isn't working out. And then we do something. The judge, whoever's handling the case, does something. If it is DSS, right, Department of Social Services, and it's a CPS case, and they say we can't get the information in time, we push back the DV, even though we have a lot of DVs. We just get a letter, they don't tell us everything. They say, oh, we can't get it done. Can you push it back at least one time, right? I'm not sure why this is handled any different. These are all same cases that are important: criminal DV, civil DV, and this. And it will back things up a little bit. But if you can get a resolution in that case, I think that is a good way to do it. So I think there has to be a mechanism from the office to get to either the admin or to reschedule it. Now, if it's been the second time up, the case is from 2020, I mean, the admin judge is going to act, in the way that they think is sufficient. But I don't think it's problematic in that way to make those suggestions and have a relationship. And here's the thing: you don't have to have it as a blanket policy. If you know that there are administrative judges throughout the counties that are amenable to that, talk to them. Set up a process to them. I know we are one court, one voice, one judiciary. I get it. But that's not pragmatic of what actually happens across the state. And so that would be my response to the pre-trial mediation.
Well, I have a question from
Who's talking? I don't know. Who's talking?
Christopher Page.
Okay, all right.
So I have a question as it relates to, we do outreach at the district court on the days that we have mediators there. So we're in Rockville on Mondays and in Silver Spring on Fridays. And then we're also, we get the pre-trials in advance. And both sets of cases from the outreach, we're not talking to anyone there. Since COVID, we've basically not seen anyone, and we've seen a significant reduction in pretrial cases. So my question is the court seeing a reduction in actually people filing, or is it just something else new is happening? You understand what my question is?
Yeah, I think you're saying, is the court just seeing a natural reduction post-COVID, or is there something missing, some information not being given where folks can engage in that process ahead of time? Is that what you're saying?
Right. Yes.
Yeah, so I don't know the answer to that question, but I will tell you what judges are seeing. In a civil context, folks want to go to trial.
Yeah.
Post-COVID, a lot of the cases that would have settled did. And now we're left with this residue. I don't mean to say residue in a bad way. Okay.
Yeah, I know what you mean.
Just remaining cases where people are really at each other's throats because they've waited through COVID. And now they're at a point now where they're like, nope, we're going to do it. We're waiting through COVID. We're going to move forward. And trying to return back, in my view, to the way it should be has become difficult. I think it requires leadership by judges who get mediation and ADR to say it at the front, be a little pushy about it. It's a voluntary process, but you can be pushy and it still be voluntary. That's one of my views. You say, look, this is good. You're going to go do it. And if they don't come to a resolution, then you just bring them back. That's, oh, it's fine. Just come back. And so I think the answer is that we're seeing people be a lot more litigious. And I think that goes to some of the comments that I made about, folks sticking their feet in the sand and not moving. But we are the leaders. We should always communicate better. We should do our best. And this COVID residue is not always going to be there. Folks are always looking at what's going on in this moment. And we should look at the moment, but we should also look at a year from now and 2 years from now, and whether or not we can fix it and change it in a way where we can still be useful and helpful in that way as well. So don't get too down on yourself about what it looks like today.
Right. Because
tomorrow matters too.
And I guess since there's no other, I don't think it's anyone else. I had one more question.
All right. Well,
this is on landlord tenant.
Yeah.
In the sense of, what do you find since the new policy? We get a lot of cases for landlord tenant. Yeah. But what are you finding as it relates to the new policy where they try to get them to go to mediation prior to? Because especially it really is super successful in Hawaii, in the Hawaii mediation program.
Right.
But here, I don't know if it's as successful because it's almost, I guess in Hawaii, it's voluntary for the person who might be getting evicted, but it's not voluntary for the company that's evicting, So are you seeing that there's a high rise in people selling through mediation or throughout the state, or has there been any research on that as it relates to the new law on landlord tenant?
Yeah, so there are 6 judges in Montgomery County that handle landlord tenant, and I'm one of them. Okay, good. Well, you say good, other folks say not good, right? It all depends. I think we have a pretty good spectrum of how judges and the 6 judges feel. I think I'm typically on one side, and there's some judges on the other side, and there's some folks in the middle based on specific how the law should be applied in landlord tenant. For your question is whether or not we're seeing any effect of having to try to do mediation. Thanks, Ed. I appreciate you. Having to do the mediation first, or try to do, offer to do it first, right? Voluntarily, right? So here's what I've seen. We've had the most success by having, and this is outside of, I've seen, but outside of this mediation is Maryland Legal Aid and CASA.
Yeah.
They stand right outside, and so the process has become, folks really go to them on the same day of trial. And I think the word is out about that. And I think also the landlords have told folks, oh, don't worry, CASA will be there, or Maryland Legal Aid. Now that's for Montgomery County, right? And we've allowed them to use some office space. We've allowed them to make announcements beforehand. We've allowed them to do things that I think has kind of shifted folks' view in the same day for landlord tenant to do. Now, when you guys get it early and there's a contested matter, I'm not sure how many are being diverted that way. But we've been fortunate enough to have Maryland Legal Aid and CASA take up a lot of the cases. So people come forward. It's still a process. Now, I don't like it just being just a process. I know some people are, because it clears the docket and it can be not complicated. But I mean, landlord tenant stuff where people live and stay in, I think should be complicated on purpose about trying to evict them. I mean, I think you should be evicted, of course, if people follow the rules, but I think the rules are pretty specific for what is requirement for landlords in this, at least in my county. For it.
Thank you.
Yeah, no
Your Honor,
yeah, who's raised their?
it's Edie,
I can't see. Okay, let me.
Edie Judice. And I'm wondering if you could explain the mechanics of the process. A dispute exists. I'm not talking about the legal framework of complaint and an answer and such,
Sure.
But once they're starting from the pre-trial, what happens? Where does the mediation referral fit, or an order fit in? And then what happens? The parties are asked if they're open to mediation. They're mandated to go to mediation. What happens? Who's there? Where does the mediation take place? What are the parameters that impact the mediation time-wise and such? How do things roll out?
Well, I'll tell you how my understanding of it is. And so to the extent that I understand it correctly, you're going to get that from me, right? So after, say, in a civil case, after something is filed, we do have like a notice that is supposed to go out with the complaint and things if it's served, or the notice of when the trial date is, that there's some mediation notice that's supposed to go out. It's supposed to go out in large claims. And I think it's supposed to go out. I think it's supposed to go out in small claims as well. I don't know the specifics of that. And so that's kind of an entry. People get the notice. The opportunity is to look and say, oh, well, maybe it's this mediation thing. I can call this number, right? To answer part of your question is it's not mandated, right? This is the difference from the story that I told about growing up in the DC multi-door, where judges would send your case back if you did not genuinely participate in mediation. There were times where I would come in and the judge would be like, hey, Zoo, that's what they call me, Tony Williams, but Zoo, hey, I got this thing, and the mediators say that you showed up and you just didn't have any authority and you just were chilling. And I'd be like, oh, well, Judge, I don't have to have, I have the requisite authority, anything that the TC told me, I had the requisite authority. And the judge would be like, oh, well, this case isn't going forward. So you can go back to mediation. Here's the due date, and you can participate. We don't have that kind of system. There's not the same ethos, and it's something that I pushed for, have not been as successful over the period of time. So there's no mandatory. Additionally, there is a question about what does mandatory and involuntary process mean. I try to tell folks that it's mandatory to go, but not mandatory to resolve. You can always come back, do the process. Other folks say, no. Making me go to the process is mandatory. I think that's not borne out in other states, but it is an argument that folks have made. Also, same day of trial, right? At least for the district court. Folks come in, we have the mediators, Mr. Kester and other folks who are there. and the judge usually has to make an announcement or is doing an initial call, and the parties are like, "Oh, judge, we couldn't settle. We're ready for trial." And you have some judges like me who are like, "You're going to go with this mediator, and you're going to try to work it out." I look for specifically power dynamics. One represented party, one pro se party. If it looks like it's a social economic thing, if there's a barrier regarding language and we get an interpreter in there, I look for like a kind of a triage, like, okay, what makes sense that, there's going to be a good outcome from both parties and kind of disrupt any type of uneven or unequal standing, right? Some judges don't do that. They just say, "Who you want mediation? You don't want mediation, it's voluntary, I'm not the same." And so I think those are some flashpoints where it could be. So number one, maybe a better way when the lawsuit comes forward to say, "Look, do this, make it easier for people to get on it," right? Number two, make it so that same day that you actually send them out and have a different view about what's going on. And then here's the other thing too. When can you have mediation? Has everybody ever thought about that? Why does everybody think you can only have mediation before a trial begins? That's not been my experience. Mid-trial, if it's the same day and there's a mediator there and folks know who appeared before, I'm like, why don't you go, all right, opening statements. Okay, here's what we're going to do. You're going to go to mediation because I haven't made any decision. Or even if you hear one side or the other, I don't think jeopardy attaches to mediation. That's not been my view in the law or anything else. So there's also an opportunity when you're hearing stuff coming. You don't have to make a judgment as a judge, but I can send stuff back out so long as there's a mediator there. Or I can say, you know what? We're halfway through the trial. I'm going to send you out to mediation. You come back in a week or whatever. The problem with that last one is that because the judge has heard some of the case, you're stuck with that judge, and administrative judges will go crazy because now you have to stick with that judge. The judge comes out of the rotation if they don't settle. And it screws up their thoughts about how to do the dockets. I'm not an administrative judge, so I don't know what those pressures are. But I have done it in the past, been dinged for it, but I get dinged for a lot of things. So, so it's part of the process. But those are some flashpoints that I think that can be helpful as well. Tim, do you have something you want to add? Is that why you're raising your hand, please?
Yes, and I'd ask for mediators who are doing this now to chime in too. But when I was doing it pre-COVID, here's the way it would come down, Edie. So Judge Smith, I don't think there are any Judge Smiths in Rockville, but anyway, Judge Smith
in the circuit court.
This is district court.
Okay.
Would tell Brown and Johnson, "I want you to go out with Mr. Stranges and mediate this case." And so they would go, and we get to the mediation room, and the first thing out of my mouth would be, even though the judge said that she wants you to mediate this case, I have to tell you that the mediation is voluntary. All I do is I'd ask you to sit for a couple minutes to hear what mediation is and how it might be able to help you. And if you decide it's not for you, you can go back into the court. So that was the way I would handle it regarding the voluntary nature. So.
Thank you for that. Yeah. I appreciate that. Yeah, because you guys are gonna know better. Alberto, are you trying to get my attention?
Yeah.
Yes, sir.
Judge, I appreciate the opportunity of asking this question because they are everyday things that we do and we don't know. We don't see the whole process, so the way that you're explaining now. But in particular, I have never done a mediation at the court, and I hope to do it someday. But in many cases in pre-trial, we came to agreement, we write a nice agreement, we send it to the office sends it to the court. What happens at that point? If the disposition of the case is automatic, there is a review, can a judge eventually reject or dismiss the agreement or overrule it? I mean, what happens when you have an agreement?
So that's a good question. The question is when an agreement is reached, especially pre-trial.
Correct.
I'm sorry?
Yeah, that's exactly the question.
What happens, right?
Yeah.
Send it in, they send it in, what happens? I can tell you In the district court, I'm not sure how it is and I'll tell you my view again, but in the district court, we can't wait to take a case off the docket. So we cannot wait. If the parties send in a 3506B or consent or a private PA, private agreement reached, right? And we can take that case off the docket because of the sheer amount of cases that we have, I get hyped. I tell people this all the time. Don't threaten me with a good time. That sounds like a good time to me. So it's probably going to come off. I do not, and this is my practice, I do not scrutinize the agreement. But I'm a district court judge. I'm not a circuit court judge. There are instances I could see maybe a circuit court judge would be like, wait a minute, what's going on? As long as both of the parties sign it, as long as they agree to it, then that's what it is. But that's for district court. I know that for other things that are going on in circuit court, judges can be a little bit more cautious about that as well. But in the district court, if it gets sent out, especially before the trial date or the merit trial date, it's going to be taken off. It's going to be settled, private agreement reached, or voluntarily dismissed by one party or the other.
Thank you.
Yep. So threaten me with good times all the time. If y'all reach it, send it. Take it off in a hurry. Okay. Other questions? I'm trying to scan folks. Harold, please. Yep. We're gonna do Harold and then Faith. Remind me to come to you next, please. Harold, you gotta unmute, sir. Yeah. Here, I'm gonna do it this way. I'm gonna click this button and it should pop up for you to click something to unmute.
There, I got it.
No worries. Okay.
Some judges will say, I want you all to step out in the hall and talk about this. And there's a mediator there. And the mediator is totally confused. Am I supposed to go out and impose myself? But
No. So I have been known to do that for specific reasons, right? Sometimes I will say, go out and step out, even if there's a mediator, because I got this interpreter case that I need to go to the mediation so that, and this other one can resolve quicker than that. What you should do is, at any time, if you're confused, you should get the judge's attention either by doing it or the bailiff or the clerk, and just say, hey, judge, do you want me to go outside and see if I can be helpful? And the judge will be like, no, either sit down, I got one for you coming up, don't you worry. Or, you know what? I forgot you're here. If you don't mind, please do that. The judge can call the parties back in and say, hey, I'm sending you to mediation. I thought about it. I changed my mind. Or if you feel comfortable doing it, that's fine as well. But I do think some instruction from the judge can be helpful in kind of pushing people toward each other, which is what we're trying to do. So that happens all the time. But I usually do like a whole, people have like these Post-its. I review the cases. I'm trying to figure out which ones make sense for judicial efficiency. So especially if there's multi party claims and things of that nature. But it's a good question, Harold. You should always be okay to approach the judge. If you think the judge is hot-headed or otherwise a hot bench, always approach the clerk. The clerks are good about getting my attention, even if I'm in the zone. My clerks can always look at me like, get out of the zone, focus, slow it down. This is what's happening. Did you forget about the mediator? Either yes, I forgot about the mediator, or I can say, no, I have a plan for you. Don't you worry. And I think all the judges will be receptive to that too.
thank you for your support of mediation all these years.
Oh, thank you so much. I appreciate you. All right. And Faith now. Ms. Faith, please.
Thank you, Judge Williams. Still on the back end, oftentimes, not necessarily with cases that come, from the court, but oftentimes in mediation, we get to an agreement, right? And in that process, we learn that what appears to be the issue on the surface is really compounded by several other issues, right? And that's the real value in mediation, right?
Yeah.
But I wonder sometimes about the lifespan of the agreements that are made. And so I was just wondering if you find, or if there are many instances of folks having made an agreement outside of the court system. They've come to mediation first, they've had an agreement, and for whatever reason, it ends up coming back to you through the court system. Is there a high incidence of that?
Yeah,
Thank you for taking the question.
no problem. It's a great question, and it gives me opportunity to brag about the judiciary. So I always appreciate those. Back when I was the chair of the subcommittee, the larger committee for Circuit Court, Court of Appeal, the ADR, we did a survey, and it's not a survey, but it was an actual study done. And there's three things that I get to say all the time when I'm telling people to go to mediation. There's three major things that we learned. It was, first of all, it was an expensive process, and we had to send them back and come back and forth till we got something that was good. We did it through the University of Maryland, which was very helpful. Three things that we know that mediation does. You can tell people this because it's true. I've read the data, and this is what it says. Number one, we learn that when people mediate, go through the mediation process or the ADR process, and solve their own issues, that they're more likely to do what is said in the agreement and stick to it than if they don't. That if a judge says, all right, judgment in favor of X, they're more likely, if they go through mediation, to do the agreement because they feel like they have some, now I'm inferring, like we don't know that, but that they have some, they've done something in the process and they say, I've created this thing and now I have to abide by it. No matter if we had an original contract or whatever, now we're at loggerheads, but we're able to find this. That's the first thing. So they're more likely to do what it said. Number two, they're less likely to appeal. So even if, and this is the good and the bad, it doesn't ultimately get paid the whole thing, or ultimately they actually talk to each other, they don't appeal because they see that there's a way forward and a path forward. That is an inference I made from the result, but the result is that they're less likely to appeal. The third thing that we found, when people go through mediation or ADR and they come to a resolution, they are more satisfied with the system than we've ever seen before. All of that stuff I said about, being at this point in America right now and the greater what's going on nationally, how people are feeling and feeling divided. When people have successful mediation, they feel way better about the system. That has nothing to do with judges or lawyers. That has everything to do with y'all and them, like self-determination, right? And you guys as well. So those are the three things we learned from the study. The study was not that long ago, and I've seen it. I've seen it when I did mediation for foreclosure. I've seen it from the view from the bench, and I know that that's what's happened. So to your question, it works and it matters. Other questions you guys have? I'm scanning. Don't be afraid. It's okay. Y'all said all real positive things. Usually people come and beat me up when I go to the communities, but that's part of the process too. That's part of the process too.
Judge, again, this is Alberto Grossman again. And one of the points that I wouldn't say struggle, but I always stumbled upon was the explanation of the three types of disposition of a case. When we finish it, when we write an agreement and we have to dispose of the case, we have to indicate, how would you, with all your experience, how would you explain in simple layman terms, how are the rules applied for disposition of a case?
So you're asking when a case resolves?
Disposed, yes, it's resolved and disposed.
So you have a voluntary dismissal, right? I would say, look, the plaintiff can always voluntarily dismiss because a private agreement's been reached. So you have the voluntary dismissal. You have, I say, this is what I tell folks, the voluntary dismissal, that's the easiest one. You can always bring it back if a private agreement reached, whether or not it's 3506B or consent or some other judgment, right? And that's what it is. Then I say, or I can dismiss the case and just call it private agreement reached. It doesn't have to be voluntary at all. I can dismiss the case. That's one of the things that I can do as a judge is dismiss cases. Dismiss case, private agreement reached. And I'm not sure what the third one is, you know, but you just tell them, you know, the case is going to be disposed of. It doesn't really matter how you dispose of it because you have this private agreement.
Well, we try to explain the case of with prejudice or without prejudice. That's what we follow, right?
Yeah. Yeah, there's not going to be a consequence as long as you have that private agreement. It might be. You can always come back, right, under the private agreement. Be like, oh, they breached a new contract. They breached a new agreement. In that way. Christopher, did you want to chime in and say something that may be different?
No, it's not different. It's more of what happens is what we give our mediators so it can be more efficient. We work with the district court and developed it based. So when they have a mediation that reaches an agreement, the parties have to check off so the clerk and the court knows how to dispose of it. They have to check off one of 3 dispositions. So it's dismissal upon stipulated terms. The second, dismissal with prejudice, and dismissal without prejudice.
Yeah, my favorite's the middle one. Yeah, just with prejudice, but yeah.
Right. So those are just I think that's what he was asking, trying to understand the 3. So you got understanding of the 3, Alberto, or do you need myself or the judge to help you with the understanding?
Yeah, I think he's trying to say how to explain it to folks because it's all getting dismissed and you don't want that last hang up to be, okay, so now how is it going to be dismissed? Is that right?
Right, that's what we're trying.
Yeah, that was exactly my point. So, but my point was, in what way can you explain it in a simple way? Because I always have to go back and forth until they get the right message, right? So
yeah, it can be dismissed one of 3 ways. I've seen all 3 ways. The first way, and I'm not sure exactly what you can say. I can say that one of the more popular ways is to do it this way because I've seen it more times. But other people do it other ways. It is your choice of what you want to do. But I'm not sure. Yeah.
So what I would say, so that for our mediators, is you try to explain it. And you just explain, and if after you've explained and explained and explained and gave examples of the 3, and really just giving them that disposition sheet and the explanation sheet, and they still don't answer, have them call the self-help, and then they would get the answers from self-help, and then they could call the office back. Hopefully their case is not in 3 days or sooner. And then that way, what we don't want you to do is say, here's how most people do it. And then you're caught into giving them advice.
Right. And they're trying to call you back. Well, this is what the mediator told us to do.
Right.
Yeah, it's an art. And like every art, you're going to have to try to figure it out, right? You're going to have to do a brush stroke. Doesn't work. Next time, do a different brush stroke. Or if it's art and music, this is the track. This is the other track as well. So I know it's not a great answer, but it's part of the art of mediation. Tim, yep, okay.
Yeah, 2 things real quick. Number 1, I found the site for that reference that you were making, Judge Williams, regarding the research that was done on the effectiveness of mediation versus judges' rulings, and I put it in the chat.
Okay.
Number 2, and you may refuse to answer this question because it's a personal question.
Go ahead.
Okay, so you have been there in Rockville for 8 years now.
Yeah.
And you're now one of the senior judges there, if not the most senior judge.
Yeah, no, Moffitt, me, and then me.
Okay, there you go. There you go. So what does the future hold for Judge Williams? Are you going to be the new Judge Bell one of these days? Because you have such enthusiasm about mediation. You remind me, and I'm aging myself, of Judge Bell, working with Rachel Wall back when, and just, being the be-all and end-all for the country. People would just flock to Maryland.
Yeah.
And, I think the things have kind of gone a little downhill since then. But your enthusiasm is so catching. Do you have any plans for aspiring to bigger and better things?
So I'll answer it two ways, right? The first way I answer it is that probably because I clerked for Chief Judge Bell, and he's been a mentor in my life, and I was doing mediation stuff right out of law school, was also helpful to it as well. Nobody can ever be Judge Bell because he had a flair about him that I can never be able to do. The first way I will answer it is I want to be where I can be the most helpful to the most people. My mom's story about coming from Guyana, and my dad's story about being on the south, born on the west side, then the south side of Chicago during the 50s and 60s matters to me, because there were people who intervened in their lives. There was people that told my mom, you can get out of this village and go someplace and do something, and we'll help you. And even though people make fun of you and you're trying to figure out your path forward, there's a path forward. For my dad, who's the youngest of 5 children, the first of the children to not be in a gang. So there was his brothers and sisters who protected him and said, you're going to stay in the house and watch TV, which is why I get a lot of pop culture, because I get it from my dad, because he would just stay in the house to watch TV, because if you got on the street, you're in a gang, you get shot. I think about the way people have interfered in their lives in a good way and disrupted. And I'm looking to do something like that in the judiciary. And when I got appointed young, I thought that this is the place for the district court to do it. I got on every committee, did everything. Spent a lot of my youthful pushing for it. And so I still am finding some success. I will admit that I'm finding less success recently, but still pushing to do those things. So wherever I can be the most helpful to folks, like my parents were helped, like people interfered and disrupted my life to help me do the right things, with mediation, with everything encompassing what we want the judiciary to look like, I'm open to it. The second thing is I think that, this is my personal view, is that we are at sort of a crossroads in Maryland concerning the judiciary and what we are going to figure out how we want to treat people and what we want to do. There's a national conversation about the judiciary, but there's also a state conversation about that as well. And I think that I have good views that need to be vetted and tested and do all the things you're supposed to do. But I think I have some very concrete views, and I'm hopeful that there's room in the judiciary for me to move to those locations. And I'm very hopeful to do that because I have the energy to do it. But I also know that sometimes to move up, you got to move out first. Not saying I'm going to move out. I'm not saying that at all. Don't go back, Judge Williams. Go, no. The thing is that in order to keep moving, you gotta keep pushing and trying to bring people together and try to find a path forward, even if you have to go around people by moving around. And so I'll leave it for that. I'll leave it at that. But I think we're at a crossroads that needs to happen probably in the next 2 years or so.
Okay, thank you, Judge, for your honesty.
Don't go run and tell people.
We're not going to go running and telling people. Our lips are sealed.
Well, it's being recorded, but I feel comfortable that I want to work within the judiciary to do good stuff for folks. So as best I can. All right, somebody else had their hand up? Oh wow! Now we have 2 hands up. Mr. Breda, what do you want to ask me? Now I'll give you all the personal questions, right? Go ahead.
It's just a statement. I want to tell you thank you and say that with the judiciary and your work, and one of the things that we talked about at Crickman but haven't been able to quite put together because of changes in focus at the state, as I understand, is we really, are interested in working with offenders who are returning to their families, and having an opportunity to do that. We just look forward to it. So I know it's late, 7:31, so I'm not trying to ask you to respond, but
no, I'm going to respond because it's something I believe in. So back in I guess about, oh my God, I'm getting old. During the Obama administration, I was able to speak at the White House about returning citizens. That's what we call them, involved or returning citizens is typically what we're called. And I've talked about having mediation or working with folks who are returning citizens. so that they can find a path forward. One of the things that I have done, 50% of the people like it, 50% don't. So there are three, I look at it in sentencing a lot, right? So there's three primary fundamental things that you're supposed to do in sentencing: deterrence, rehabilitation, and punishment, right? Those are the three traditional ones from old England, right? That's what you're always supposed to look at. But I also think that there is room for a fourth and fifth, or a combo, right? Restorative justice and reentry. And it is my view, and I've said it many times, that when judges are making determinations of sentencing, that reentry should be part of the mix. Because we know that, based on statistics, that if you send somebody away for a long period of time, it is more difficult for them to return, to go back into society. And so if I have a judgment about whether or not I'm going to, send somebody to jail for 6 months versus a year, but I know at the year point, employers aren't looking at them in the same way, I think judges should make a thought about, well, do I really need to incarcerate this person as punishment if I'm also trying to make sure that they break the cycle and are returning citizens and involved citizens? And there's many other things that I think judges should look at in that point, at that point in time, that I don't think a lot of judges do. They just do the three traditional. I think that the three traditional ways have helped lead to mass incarceration, which is a problem in America, I think. The solutions, I think people have to try to figure out a path forward, but we also have to make sure folks are safe. But the question is whether or not putting X more months, X more years on somebody's sentence actually makes people safe, right? And whether or not, how does it disrupt that person going in one direction as well? And so I love the question. If I move up, or if I end up someday in the Court of Appeals or leading in that way, right now, that's my view. Okay, so but I'm open to folks, other folks' views as well. But yeah, and it was really cool to speak at the White House. Very, very cool. Anybody? I thought it was one more hand, and I think it got put down.
That was my hand. And the funny thing, Sabrina was asking somewhat because of what you were talking about.
Yeah.
One of the programs it's Chris again. One of the programs that we have in our mediation center is our restorative practices program, where we do reentry mediation, but we call it, we go from the school to prison pipeline. We try to be a part of the entire thing and doing some of the stuff before they get to sentencing. So I was going to ask you basically what Sabrina asked: what is your views on restorative practices? And even from in the part before the sentencing, not the re-entry part, but the sentencing part, where you do the restorative practices, where the victim is in mediation and they are a part of, quote unquote, the sentencing. And how do we do, what is your concept, or what is your just feeling of seeing how restorative practices, from the standpoint of how a lot of people on the strong restorative practice side envision it? How do you envision it being from the judiciary side? You understand what I'm asking?
Yeah, so yeah, I do. When I look at restorative justice, and especially, listening to the victims, because that's a part of it, right? Allocution, victim impact statement, those are all things on the criminal side that matter. One thing that I think that we could do better about, and it would slow down the process a little bit, unless we got to the point where we did it as a matter of fact. When I was clerking and doing stuff on the federal level, we would get pre-sentencing reports all the time. As a matter of course, when somebody got sentenced, automatically parole and probation, or whoever did it at the time, would give us a pre-sentencing investigation report. And I remember that because on every day, the judge will go back into the room with the agent and go over every single person that he's going to sentence during that time. So number one, it means that you'd have to have the sentence date different than the conviction or the trial date. So that's going to make time a little bit longer. And then it's going to have to be a normal process for getting it, because the judge would be like, okay, what are their sentencing guidelines? Because it was federal, right? And they were advisory. They had just turned into being advisory at that time. But here's what it does. It reads like a story, and nobody's trying to spin you. Spinning me because, the agent works for the court. You read that, and then you get a chance to hear from the plaintiffs of the state, and then from the defendant as well. And you get to make some really important decisions based on that. You don't have to follow it or anything, but if you check that, that means that The agent has to, for every case that you sentence somebody, do it in. In a district court, people are going to say it's not feasible because we have such a heavy docket and you can't do that for every case. Well, that may be true, right? You can't do it for every case. But I do know some DV criminal cases we could do it in. We could see some repeat offender cases for theft cases we could do it in. We could see repeat drug cases that we could do it in. We don't have to do it for every case, but every judge and every lawyer knows that there's some cases where something's going on. And we should take a look to see, and we can do it for those cases, but it's going to slow stuff down. And so you have to weigh whether or not people are willing to slow justice down to do justice, or whether or not it's not doing justice because we're not getting through the docket. Like I said, I'm not an administrative judge. I don't get to see the numbers, you know, so I'm not sure exactly how that works. But I think there are some ways, you know, there's never ever we can't do anything. Very rarely has there been a we can't do. We can try this, try that. Let's try this time. This didn't work. And then if you get a new admin judge or a new chief judge of the district court or whomever, maybe they have a different view. Different admins have different views about how to move forward. And the other thing I will say is when they say that parole and probation is not used to doing it, it slows things down. You're never used to doing something you do once every year.
Right, right.
But if you're forced to do it once a week, 52 times or however many times you're working, you're going to get pretty good at it. You're going to streamline it. Right. But if you're not given the opportunity, then it's, you know, a self-fulfilling prophecy, right? That it's never going to happen.
Mm-hmm.
But that's again, my personal view. And I don't see everything at the top, but I think I kind of know what justice looks like sometimes. And so, yeah, which is why I think it looks like. I could still be wrong.
Thank
Other
you.
questions? I got all night. I already made pulled pork tacos for the kids tonight. And they're all set and they're ready to go. My wife had tag team. She's doing it, but they got their pulled pork tacos. So it's up to you guys. Anything else you want to hear from me? Y'all look afraid to ask, but that's okay. Thank you so much for giving me the opportunity to speak to you.
Well, hold on, before you go,
Yeah.
it's two things. Well,
Sure.
three things. One, I'm gonna give a quick thing because I want to promote Tim's workshop that he's doing next month again, and I'm gonna do it strategically. We have in the chat, Andrea has placed the survey for the evaluation of this workshop. What are your feelings? What are your thoughts? And we want you to make sure you fill it out and also let you know that one of the things that Tim is presenting on is about evaluations, giving strategies, how to get the evaluations, because we were just awarded our macro grant. We just found out this morning we got our macro grant. It was approved, but one of the things they wrote in the macro that we have to write is a goal about how we're going to increase receiving evaluations. And so we really need you to come to Tim's training, because if we don't reach that goal, we might not be able to be doing this service. So we need you. We definitely need your support. It's very important. And we need you to evaluate this service, this workshop. I think we want to thank you, Judge. And here goes the thing. We taped this for what we're doing. We taped this because we're going to take some clips from what you said and put it on Instagram, social media, TikTok. And one of we really valued the 3 points of mediation, what you feel about what that study says. So I know we're going to use that. We're going to use some other ones, but we want to make sure you have the voice. Anything that you might want to say, any inspiring things about mediation, about yourself, or anything you want to say that we might use. So we're giving you the spotlight again, that it's on you if you have anything you want to say.
I'm so very proud of the work that mediators are doing across the state of Maryland, and particularly your group. Talking to judges in the raw way that you have talked to us today about some of your concerns about what's going on, trying to illuminate light so that we can all move in a positive direction to serve people is essential. Everything that I've said here has been, my view, and I know that some folks may differ on it, but what folks should never differ in is that people coming together and solving their problems with a little bit of help from the court, a little help from mediation, and it being part of the process is paramount. I think it does good for evening out perceived unevenness for socioeconomic, having lawyers and doing other things, and it gives you an opportunity to speak where you might not be able to put in and speak during the trial as well. I think it's a very good thing that we're doing and moving forward. But here's what I also know. We are never perfect. Just because we've done something in the past that hasn't worked doesn't mean we shouldn't try it again. Just because we think that we are rolling and rocking and rolling, because people love to come to Maryland and try to figure out how our mediators are doing, doesn't mean that we should not stop moving toward excellence. It's not about us. It's not about ego. It's about making sure that their service industry serves the people of Maryland and also of the country as well. High hopes, high expectations matter. To whom much is given, much is required. So we're requiring a lot from folks and folks like you. I'm so very proud for you bringing me in here. I promise you that I will do my best to be equal to folks, listen to folks, and make sure that this type of process, ADR and mediation, is always going to be a part of the process. It is important and it matters. Thank you very much.
Wow, thank you. I hope that part of the clip goes viral because it was very inspiring, and it's something that really, all the stuff that you said this evening was very needed to be said, and I thank all the mediators for everybody who came. You gotten a high response from a bunch of people, and here goes the thing: when you mentioned going to lunch at Apollo, we just had that same. They moved to a new restaurant. They just had what's the restaurant, Tim, that you went to today for the lunch?
It's El Mariachi, which is just down Rockville Pike, maybe a mile from the courthouse, if not.
Yes.
So I can put you on the invitation list. So,
Put me on.
Okay.
Hey, good.
Will
Keep
do.
going. I know we always had Judge Wolf on there, and he would come occasionally and bring you, and I appreciate that. It was good times.
Yeah, it was good. And I'm very thankful again to Judge Wolf and Judge Patty Mitchell
Yes, Patty.
for really pushing these things and helping make me the judge I am today. I could not have done it without them.
And thank you. And the work that you're doing is valued, and it really shows us where a lot of people, like you say, there's a lot of things. Sometimes it's more negative than positive about the judiciary. And one of the things we love to see is when you get to see you here, not on the bench, but see you in front of the people, seeing what you're passionate about, what you're striving to do. People can hear it from you and see that it comes through actions as well. So we thank you. And we look forward to working with you. We look forward to getting more cases, and we'll have some mediators there, ready there when you send them out.
Sounds good. The only other thing I will say is that I'm on Instagram too. So if you want to tag me or reach out to me,
oh yes,
you absolutely can. I just put it in. It's Zublaw, Zublaw. Anybody can reach out to me. That's the way.
Okay.
You try to be accessible to everybody. So that way everybody can see what I'm doing, transparent. There's nothing that anybody can say, oh, he's doing this thing. That's the way I do it. I think we need to reach people where they are, and I think people are on these types of things. So that's why I do it.
Thank you for
and
your.
You're not on Instagram. I mean TikTok, doing TikTok videos.
I'm not doing TikTok. I can't.
I'm joking with you.
Yeah, absolutely. Thank you so much, everybody. Have a great night. I'm so excited. Thank y'all very much.
All right. Thank you.
All right. Bye-bye.
Bye. Andrea, great work.